number of.
But you're going to the greatest degree. The safe harbor doesn't require you necessarily to terminate someone. But what I'm troubled by is that you got these reports, and it's about 1% of your customer base who's infringing. There are things you could have done to respond to those infringers, and the end result might have been cutting off their connections, but you stopped doing anything for many of them. You didn't try to work with universities and ask them to start to look at an anti-infringement notice to their students. You could have worked with a multifamily dwelling and asked the people in charge of that dwelling to send out a notice or to do something about it. You did nothing. And in fact, Counselor, your client's sort of laissez-faire attitude towards the respondents is probably what got the jury upset. Meaning you're talking something very different than Twitter, where it's not even clear that their websites were being used for the specific attack at issue. Here, you know that a particular location is infringing, and most of the time you're doing nothing. Why aren't you contributing to that infringement?
So, Your Honor, a couple of things. First, on the first point you made, the DMCA does purport to require termination, and it is the failure to terminate.
But there's 10 steps, at least 10 steps before that.
I'm talking about the DMCA, the statute itself,
the statute.
The safe harbor. And that was the theory of liability, that we did not terminate people enough. Plaintiffs in their brief to this court for the first time have made the assertion that you will find nowhere in the Court of Appeals brief that we did nothing. The notion that Cox did nothing is absurd. I will mention just 3 facts that are undisputed. First, Cox invested its own resources to create the first of its kind anti-infringement program. There was no precedent for that. Second, under that program, Cox sent out hundreds of warnings a day. To your point, Your Honor, that we didn't work with universities, we most certainly did. The first several steps, the 13 steps, are all about contacting them, cutting them off, that is, suspending their accounts, which we did 67,000 times in the course of this period. That's thousands every month. And third, the program stopped infringement by 98% of the people who were accused of infringement. That is not nothing, Your Honor.
Well, can I ask you